If you think back to early 2020, the COVID-19 pandemic, suddenly just gathering with people, family, friends, even for church, it became this flashpoint, right? Public health versus our freedoms.
It really did. It threw that whole tension into sharp relief. Individual liberty versus, what society needs.
And you might remember that case in D.C., Capitol Hill Baptist Church v. Bowser, where the church, well, they eventually won the right to hold services outdoors.
Yes, that's a great example. It really shows how these conflicts play out.
Yeah.
And it underlines something crucial your sources point out. These civil liberties we value in the U.S., they aren't just automatically safe because they're written down.
Parchment barriers,
Yeah.
one source called them.
Exactly. That saying, often linked to Jefferson, but actually John Philpott Curran, eternal vigilance is the price of liberty. It's true. These protections need constant attention from everyone.
Okay, so let's really dig into this. In this deep dive, we're using your sources to get at what civil liberties really are, but not just definitions. We need to see how they're balanced, against what the community needs or even against the rights of other people. That balancing act seems central.
It really is. And maybe the first thing to do is clear up two terms people often mix up: civil liberties and civil rights.
Good idea.
Civil liberties basically are limits on government power. They're shields protecting our freedoms from government interference. Think the First Amendment stopping the government from prohibiting the free exercise of religion. That's a limit on the government.
Okay, so liberties are about stopping the government from doing certain things. What about civil rights then?
Civil rights are different. They're guarantees that government officials will treat people equally, making sure decisions aren't based on things like race or gender, but on merit.
Like banning discrimination in schools that get public money.
Exactly. That's a classic civil rights protection. We saw the injustice of segregation, and more recently, your sources mentioned things like the family separations in El Paso. These highlight why we constantly need to protect civil rights.
Those examples really make it concrete, don't they? Not just abstract ideas. Now, where did these concepts even come from? Goes back to the founding, doesn't it?
Way back. The whole idea of natural rights was central to independence.
Wow.
Jefferson, writing the Declaration of Independence, he leaned heavily on John Locke. This idea of unalienable rights that governments can't just take away.
Life, liberty, and the pursuit of happiness.
Right. And while the Declaration itself isn't law, that phrase, all men are created equal, it became this huge touchstone for rights movements later on.
Such powerful words. But it's interesting, the original Constitution in 1787, it didn't have a Bill of Rights, did it?
No, it didn't. The Federalists, the ones pushing for the Constitution, they basically argued it wasn't necessary.
Why not?
They felt the Constitution already limited the government enough by listing or enumerating Congress's powers. And they pointed to specific limits already in Article 1, Section 9.
Okay, Article 1, Section 9, remind us what's in there.
It stops Congress from passing bills of attainder, basically,
Yeah.
punishing someone without a trial. It also bans ex post facto laws, making something illegal after someone's already done it.
Gotcha.
And crucially, it limits suspending the writ of habeas corpus.
Habeas corpus, that's the right to challenge your detention, right? To make the government justify why they're holding you.
Precisely. It's fundamental. And your sources bring up key historical moments where this was tested. Lincoln during the Civil War, the ex parte Milligan case,
Right.
or the internment of Japanese Americans in World War II, the ex parte Quarren case. These were times when that balance between security and liberty, especially around detention, was really debated.
Yeah.
And you also see it in things like the Abrams case, Justice Holmes's dissent about free speech during wartime.
So the Federalists thought these built-in checks were sufficient. But the Anti-Federalists, they weren't buying it.
Not at all. They were deeply worried about the new federal government becoming too powerful. They looked at the elastic clause.
Article 1, Section 8, the necessary and proper clause.
Yeah, that one. They feared it could let Congress do almost anything. They absolutely insisted on explicit guarantees of individual rights to prevent tyranny.
And wasn't there a quote from an Anti-Federalist, Brutus, capturing that fear?
Yes, likely Robert Yates. He basically said the federal government's power was as complete. It reaches to everything which concerns human happiness. Life, liberty, and property are under its control. His point was, if state governments needed limits, this powerful new federal one definitely did. And history, as your source suggests, kind of proved him right about federal power expanding.
So this disagreement almost sank the whole Constitution. How did they bridge that gap?
It was a huge sticking point, especially in crucial states like New York and Virginia. The Federalists knew they needed those states for the whole thing to work, even if technically only 9 states were required for ratification.
So a compromise.
Exactly. The deal was ratify the Constitution now, and we promise to consider amendments later based on what the states suggest.
And James Madison really stepped up to make that happen.
He did. In the very first Congress, he proposed a list of amendments. He drew from state constitutions, like Virginia's Declaration of Rights, and the ideas from the ratification debates.
And those proposals were debated.
Heavily debated. 12 were sent to the states, and 10 were ratified by enough states to become what we now call the Bill of Rights.
And the source material includes that helpful table listing them out. Good refresher.
Absolutely. You've got the First Amendment freedoms, religion, speech, press, assembly, petition, then the Second Amendment on arms, third on quartering soldiers, fourth on searches and seizures.
Then the rights of the accused in 5 through 8.
Right. And then the ninth and 10th, which are more about interpretation.
So even with the Bill of Rights added, that argument about federal power didn't just vanish, did it?
Oh, not at all. The Federalists still worried listing rights might imply only those rights were protected. But the Anti-Federalists' fears seemed justified pretty quickly with the Alien and Sedition Acts in 1798.
Under President John Adams.
Yeah.
Those sound pretty alarming.
They were. They let the president deport or jail foreigners deemed dangerous and crack down hard on speech criticizing the government.
That seems like a direct hit on the First Amendment right after it was ratified.
It certainly looked that way. The courts didn't rule on them back then, but most scholars today think the Sedition Act, especially, was unconstitutional. It's a really stark early example of that tension between security and liberty. And one part, the Alien Enemies Act, is actually still on the books.
Wow. Okay, so it's constant tension. Now, something crucial your sources highlight.
Yeah.
Initially, the Bill of Rights only applied to the federal government, not the states.
That's exactly right. The Supreme Court made that clear in 1833 in Barron v. Baltimore. Chief Justice Marshall basically said the Constitution wasn't intended to limit state governments in the same way it limited the federal one.
So states had their own constitutions, maybe their own protections, but the Federal Bill of Rights didn't touch them for a long time. What changed that?
The Civil War and the amendments that followed. The 13th, 14th, and 15th. Abolishing slavery was just the start. Afterwards, Southern states passed these awful black codes.
Designed to keep formerly enslaved people down, right?
Absolutely. They severely restricted their rights, tried to maintain a system of near slavery.
How did the federal government push back?
The radical Republicans in Congress were furious. Their long-term answer was pushing through constitutional amendments to guarantee the rights of black men and women. The 14th Amendment, ratified in 1868, became the key tool for extending liberties and rights to the states. Then the 15th protected voting rights, at least for men.
So the 14th Amendment is the linchpin for making the Bill of Rights apply to states. Which parts of it are most important here?
2 key clauses. First, the Privileges or Immunities Clause. It says states can't make laws that abridge the privileges or immunities of citizens of the United States. There's been a lot of debate about what exactly that means.
Did it mean the whole Bill of Rights should apply to states?
Some argued that, but it hasn't played out quite that way. Still, the court has used it to protect certain rights from state interference, like the right to travel between states in Sines v. Roe, or applying the right to bear arms to the states in McDonald v. Chicago.
Okay, so that's one part. What's the second key clause?
The Due Process Clause. It says states can't deprive any person of life, liberty, or property without due process of law. Just like the Fifth Amendment's version for the feds, this guarantees fair procedures and that government officials have to treat people fairly.
And this is the clause the court has used most often to apply Bill of Rights protections to the states.
Exactly. Through interpretation over many cases, the court has said states can't violate certain fundamental liberties protected by the Bill of Rights because that would violate due process. The Schubert v. Werner case, where someone couldn't be denied unemployment benefits for refusing Saturday work due to her Sabbath, is an early example of that principle in action.
So it wasn't like flipping a switch. The 14th Amendment didn't just automatically apply the whole Bill of Rights to the states. It was gradual.
Precisely. That's the concept of selective incorporation. It's this slow, case-by-case process. where the Supreme Court decided that specific rights in the Bill of Rights are so fundamental, so essential to liberty, that the 14th Amendment's Due Process Clause requires states to respect them too.
Like picking them out one by one.
Kind of. Not everything's been fully incorporated. The Fifth Amendment right to a grand jury indictment for felonies, for instance, doesn't fully apply to the states. But others have, like the Second Amendment right to bear arms in McDonald, or freedom from prior restraint on the press from Near v. Minnesota. It's been this ongoing evolution.
Fascinating. Okay, let's dive deeper into those basic freedoms, starting with the big one, the First Amendment. We hear about it all the time.
We do. It packs a lot in. It covers religious freedom and freedom of expression. The text says Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances.
Phew. Okay, let's break that down. The religion part has two clauses, establishment and free exercise. Let's start with establishment. Congress shall make no law respecting an establishment of religion. What does that mean practically?
At its core, it means the government, federal, and now state can't set up an official state-sponsored church. Think back to Europe when the U.S. was founded. Many countries had established churches.
And the founders wanted to avoid that.
Yes. They saw the religious conflicts it caused. Even though early America was mostly Protestant, there was enough diversity even then to make a single national religion impossible. Today, it's understood more broadly. Government can't favor one religion over others, or even religion over non-religion. It has to stay neutral.
The wall of separation between church and state, as Jefferson put it. How do courts figure out if something crosses that line?
Well, for a long time, they used something called the Lemon Test from a 1971 case, Lemon v. Kurtzman. It had 3 parts.
Okay, what were they?
First, the action has to have a secular, non-religious purpose. Second, its main effect can't be to help or hurt religion. And third, it can't create excessive government entanglement with religion.
The source used a school voucher example. How would that play out under Lemon?
Right. Vouchers for private or religious schools. Well, the purpose might be secular education, and it doesn't necessarily inhibit religion. The tricky part is entanglement. If vouchers cover textbooks, transportation, maybe okay. But if the money could pay for religious teaching, the government might have to monitor that closely, leading to excessive entanglement.
Education seems like a constant battleground for this stuff, like prayer in public schools. That seems to pull both religion clauses in opposite directions.
It really does. The Free Exercise Clause protects a student's own right to pray, individually or in groups, as long as it's not disruptive. But the Establishment Clause means the school itself can't organize, lead, or endorse prayer. That would be the government establishing religion. So voluntary student prayer is generally okay. School-sponsored prayer is not.
What about things like blue laws? Those old laws restricting business on Sundays. Aren't they religiously based?
They often originated that way, yes. But
Yeah.
courts have generally upheld them, saying they serve a secular purpose, now providing a common day of rest for everyone's general well-being. Like in Bergen County, New Jersey, where many stores are still closed on Sundays.
Interesting justification. And what about things like "In God We Trust" on money, or "Under God" in the pledge?
Those are usually seen as ceremonial deism. The idea is they're more historical or patriotic acknowledgments of a general belief in God in society, not the government actively pushing religion. The under God part, for instance, was added during the Cold War to contrast with the officially atheist Soviet Union.
So it's about context and perceived endorsement. What about prayers at, say, town council meetings?
Generally allowed. The thinking is that adults attending can tell the difference between the government allowing a prayer and endorsing it. It's seen differently than, say, putting the 10 Commandments up in a courthouse, which courts have sometimes said is an endorsement, especially if other groups aren't given equal access to display their symbols.
Okay, that helps clarify the Establishment Clause. Now, the other side, the Free Exercise Clause, or prohibiting the free exercise thereof. What's protected here?
This protects your right to believe and practice your religion as you choose without the government stopping you unfairly. The conflicts usually pop up when a general law, one that applies to everybody, happens to clash with someone's specific religious practice.
And the question becomes, does the government have to make an exception?
Exactly. The Jehovah's Witnesses cases from the 30s and 40s are a key example your source mentions.
Refusing to salute the flag, things like that.
Yes, and reciting the pledge and their door-to-door evangelism. They faced a lot of hostility and legal challenges. Initially, the Supreme Court wasn't very protective, but eventually it shifted and upheld their rights to practice their faith peacefully, even if it was unpopular. It really shows that balancing act.
What about conscientious objectors to military service?
Another area where free exercise comes up. People object to war based on religious or moral beliefs. The courts have recognized this, but with limits. In Gillette v. United States, the court said you have to object to all wars, not just a specific one you think is unjust, to qualify for conscientious objector status.
So again, balancing. Did the court develop a specific test for when religious practice could be burdened by law? The source mentioned the Sherbert test.
Yes, in the 60s and 70s, cases like Sherbert v. Verner and Wisconsin v. Yoder established that test. Basically, if a law substantially burdened your religious practice, the government had to prove two things: a compelling governmental interest for the law, and that the law was narrowly tailored, the least restrictive way to achieve that interest.
That sounds like a high bar for the government.
It was. It made it pretty tough to justify laws that impacted religion.
But that standard changed. The Smith case in 1990.
Right. Employment Division v. Smith. This involved Native Americans using peyote in religious ceremonies. The court significantly lowered the bar. It said that if a law is neutral and generally applicable, meaning it applies to everyone and isn't aimed at religion, then it's usually constitutional, even if it happens to burden someone's religious practice. No automatic need for an exemption.
That must have caused a stir.
Big time. Religious groups were very concerned this would make their practices vulnerable. Congress responded by passing the Religious Freedom Restoration Act, or RFRA, in 1993.
Trying to restore the higher standard.
Essentially, yes, at the federal level. And later, the Religious Land Use and Institutionalized Persons Act dealt with specific areas. Plus, many states have their own RFRAs or court interpretations that still use something like the old Sherbert standard.
And RFRA itself became controversial, especially with businesses claiming religious objections, like in the Hobby Lobby case.
Exactly. Burwell v. Hobby Lobby. The company objected to the Affordable Care Act's contraception mandate on religious grounds. The Supreme Court, citing RFRA, said closely held corporations could have religious freedom claims and didn't have to provide contraception coverage if it violated the owner's sincere beliefs, as long as the government had other ways to ensure access for employees. That really fueled debate about corporate religious rights.
And that tension continues with issues like businesses refusing services for same-sex weddings, right? Like the Masterpiece Cake Shop case.
Yes, post-Obergefell. It pits religious freedom claims against non-discrimination principles. Some argue businesses shouldn't be forced to participate in events violating their faith. Others say businesses open to the public must serve everyone equally. It's incredibly complex and divisive.
But it's crucial to remember free exercise isn't absolute, right? Some things are just off limits, regardless of religious belief.
Absolutely. Courts have consistently said some public interests override religious claims. Laws against polygamy, illegal drug use, though there are very narrow exceptions. Human sacrifice, those are upheld. But, as your source notes, even during COVID, the Supreme Court did step in to block California's total ban on indoor religious gatherings, citing free exercise.
Okay, that covers the religion clauses thoroughly. Now, let's shift to the other major part of the First Amendment. Freedom of expression, speech, press, assembly, petition. We tend to lump these together now.
Increasingly, yes, especially with technology blurring lines between speaking and publishing. It's interesting, though, your source points out that major free expression fights were less common before the 1900s, even though some censorship existed, like blocking abolitionist mail during the Civil War.
Things heated up around World War I and the Red Scare. That's when we got the clear and present danger test.
Exactly. Schenck v. United States, 1919. People urging draft resistance. The court said speech creating a clear and present danger to national security isn't protected. That standard held sway for quite a while.
But the approach loosened up later, maybe in the 60s. Brandenburg v. Ohio.
Yes. Amid the civil rights movement and Vietnam protests, Brandenburg set a higher bar. Speech is only unprotected if it's intended and likely to produce imminent lawless action. Just advocating revolution in theory wasn't enough. This is also when the court started clearly protecting symbolic speech.
Actions that communicate, like wearing an armband.
Right. And that leads to some fiery debates, especially about the flag burning.
Extremely contentious. What did the court say?
In Texas v. Johnson, 1989, the court ruled flag burning is symbolic speech protected by the First Amendment. Huge public outcry. Congress passed a Flag Protection Act. The court struck that down, too. There have even been failed attempts to amend the Constitution to ban flag desecration. It really makes you think, doesn't it? Should the Constitution be amended to protect symbols like the flag?
Definitely food for thought. Okay, freedom of the press. What's prior restraint?
That's when the government tries to stop something from being published before it comes out. Censorship beforehand. The Supreme Court has said this is almost never okay. Think Near v. Minnesota or the Pentagon Papers case. It's presumed unconstitutional.
So even if someone leaks classified info, the press usually can't be stopped from publishing it, though the leaker might get in trouble.
Generally, yes. The focus is on punishing the leak, not censoring the publication. Edward Snowden is a recent example of that dynamic.
What if the press publishes something false and damaging? Defamation.
There are protections, but they're higher for public figures. New York Times v. Sullivan, 1964, established the actual malice standard. A public figure suing for libel has to prove the publisher knew it was false or acted with reckless disregard for the truth. It protects criticism of public officials.
But freedom of expression isn't unlimited. There are categories of speech not protected.
Definitely. Incitement to immediate violence, fighting words likely to provoke a brawl, genuine threats, and defamation, libel, and slander. The court has even allowed bans on threatening symbols, like cross-burning, done specifically to intimidate.
What about obscenity? That seems like a slippery concept.
It is. Justice Stewart famously said, "I know it when I see it." The court tried to define it with the Miller test in 1973.
What does that involve?
It asks three things. Does it appeal to the prurient interest by community standards? Does it depict offensive sexual conduct defined by state law? And does it lack serious literary, artistic, political, or scientific value? Community standards makes it tricky, but child pornography is universally considered unprotected and illegal.
And the rules are different for, say, broadcast TV versus movies or the internet.
Yes. Broadcast TV and radio face indecency regulations, a lower standard than obscenity, especially regarding kids. Think the Janet Jackson Super Bowl incident. Films on the internet generally have more protection, though laws like the Children's Internet Protection Act require filtering in schools and libraries getting federal funds.
And businesses can be required to put certain info out there, like nutrition labels.
Right, that's compelled commercial speech. The government has more power to mandate disclosures for consumer protection. False advertising isn't protected either.
What about students in public schools? Same free speech rights as adults.
Not quite. Tinker v. Des Moines said students don't shed their rights at the schoolhouse gate, but schools can limit speech if it's substantially disruptive or infringes on others' rights. Hazelwood v. Kuhlmeyer gave schools more control over school-sponsored speech, like newspapers, for pedagogical reasons.
Okay, that covers the First Amendment's expression side. Let's tackle the Second Amendment, the right to bear arms. Always a hot topic.
Hugely debated. The text is, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The core argument for centuries was, does this protect a state's right to have a militia or an individual's right to own guns?
What was the view before the Civil War?
Mostly tied to militias. It was seen as a common law right for white men, partly about maintaining order, and importantly about keeping weapons out of the hands of enslaved people.
But after the Civil War, with selective incorporation and the Black Codes trying to disarm freedmen, the debate heated up again.
Exactly. Southern states passed laws specifically targeting black gun ownership. The Supreme Court, in United States v. Cruikshank, acknowledged a common law right, but didn't see the Second Amendment itself as blocking those state laws back then. Then, over the next century, we saw gradual gun control efforts, federal and state, often responding to things like gangsterism in the 30s or social unrest in the 60s, and later, background checks.
And Supreme Court rulings during that time were a bit unclear.
Yeah.
Like United States v. Miller.
Yeah, Miller 1939 was often read as supporting the militia view. It upheld a ban on sawed-off shotguns, saying they weren't ordinary militia weapons. Lower courts mostly followed that line for decades, upholding regulations.
Until District of Columbia v. Heller in 2008. That was a bombshell, right?
A landmark shift, a 5-4 decision. The court said, for the first time, the Second Amendment does protect an individual's right to have a handgun in the home for self-defense.
But that was just D.C., a federal district.
Right. So then came McDonnell v. Chicago 2 years later in 2010. That's the case that incorporated the individual right, applying it to the states via the 14th Amendment. It overturned the old understanding from Cruikshank on this point.
But the right isn't absolute, even after Heller and McDonald.
No, the court made that clear. Reasonable restrictions are still allowed, bans on felons or the mentally ill possessing guns, for example. And we saw the court let some San Francisco regulations stand in 2015. The debate over what counts as reasonable is, of course, intense, especially after mass shootings.
Okay, moving to the Third Amendment. No quartering soldiers in homes without consent. Seems very historical.
It definitely stems from grievances against the British before the Revolution. But your source makes a good point. It can also be seen as reflecting a broader idea. The home as a private zone the government shouldn't easily invade.
Which leads nicely into the Fourth Amendment. Protection against unreasonable searches and seizures. Super relevant today.
Absolutely critical. It protects our persons, houses, papers, and effects, and says warrants are needed based on probable cause, describing specifically what's to be searched or seized.
So the default is get a warrant. But there are exceptions. Lots of them.
Quite a few developed by the courts. If someone consents to a search, if there's no reasonable expectation of privacy, like trash left on the curb, exigent circumstances, immediate danger, evidence being destroyed, if evidence is in plain view.
And specific ones like searching cars during traffic stops or at the border.
Yes, those too.
What exactly is probable cause? It's needed for warrants.
It's the standard police need to show a judge, basically a reasonable basis from trustworthy info to believe a crime occurred or evidence will be found. It's less than proof needed for conviction, but more than just a hunch.
Though critics say warrants can be easy to get sometimes, and we've seen controversy around no-knock warrants recently.
Yes, the Breonna Taylor case led to restrictions on those in many places.
What if police do search illegally and find evidence? Can it be used?
Usually not. That's the exclusionary rule from Mapp v. Ohio, applying it to states, building on weeks for federal cases. Illegally obtained evidence gets excluded from trial.
And anything found because of the illegal search is also excluded.
Right, the fruit of the poisonous tree doctrine. But there are exceptions here too, like the good faith exception if police reasonably relied on a faulty warrant or inevitable discovery if they would have found it legally anyway.
And probable cause is generally needed for arrests too.
For arrest warrants, yes. Though police can make warrantless arrests for felonies if they have probable cause, or for misdemeanors committed in their presence. And importantly, the court has said Fourth Amendment protections apply to new tech, like needing warrants for GPS tracking, Jones, or getting historical cell phone location data, Carpenter.
Okay, that sets up the rights of suspects covered in Amendments 5, 6, 7, and 8. Let's hit the fifth first. It's a big one.
It really is. It covers grand jury indictment for serious federal crimes.
Which isn't fully applied to the states, right?
Correct. Many states use preliminary hearings instead. It also doesn't apply in the military. Then there's double jeopardy.
Can't be tried twice for the same crime by the same government level. But federal and state can both prosecute.
Yes, the dual sovereignty doctrine allows that. The Rodney King case is an example. And double jeopardy is only for criminal cases. It doesn't block civil suits, like with O.J. Simpson.
Then the famous part, the right against self-incrimination. Taking the fifth.
Codified in the Miranda v. Arizona warnings, police have to inform suspects in custody of their right to remain silent and right to counsel before interrogation. Though Miranda warnings aren't required in every police interaction, only custodial interrogation.
The fifth also has a due process clause, like the 14th. But this one applies to the federal government.
Right, guaranteeing fair treatment and procedures by the feds. Things like the Patriot Act after 9/11 definitely tested the boundaries of these procedures.
And finally, the takings clause. Eminent domain. Government taking private property.
Yes, for public use, but they have to pay just compensation, traditionally used for roads, schools, etc. But the controversy ramped up when government started using it more for private economic development.
The Kelo case.
Kelo v. City of New London, 2005. Huge backlash. Many states then passed laws restricting eminent domain for private gain. We still see debates about it, like for the border wall or with regulations affecting online businesses, and there's been a push against civil forfeiture, too.
Okay, on to the Sixth Amendment. Rights during the actual criminal trial.
Yes, guarantees a speedy and public trial by an impartial jury in the area where the crime occurred. You have the right to know the charges, confront witnesses against you, compel favorable witnesses to testify, and have a lawyer.
Speedy trial doesn't have a hard deadline, but long delays need justification. And public trials aren't absolute if needed for fairness. Plea bargains often replace jury trials now, right?
Very common. Saves time and resources, offers defendants potentially lighter sentences, but the right to an impartial jury is still fundamental. Jury selection aims to weed out bias.
Confronting witnesses, presenting a defense, crucial parts of a fair fight.
Absolutely. And the right to counsel, hugely boosted by Gideon v. Wainwright.
That's the case establishing the right to a free lawyer if you can't afford one in serious criminal cases.
Exactly. Clarence Gideon's handwritten appeal from prison led to that landmark ruling. It's since been extended to any case with potential jail time. Huge impact, increased need for public defenders.
So the Sixth Amendment really shapes the courtroom process, the jury's role, needing unanimous verdicts in most criminal cases.
Yes, and the difference between a not guilty verdict and guilty, leading to sentencing.
Then the Seventh Amendment jury trials in civil cases at the federal level.
Right, if the amount in controversy is over $20, basically, unless both sides waive it. This right isn't always applied to the states for smaller civil claims, and it limits judges re-examining facts found by a jury.
Finally, in this section, the Eighth Amendment, no excessive bail or fines, and no cruel and unusual punishments. That last part is where the death penalty debate lives.
It is. Historically, it banned torture. Today, debates focus on methods like lethal injection. The Supreme Court hasn't defined cruel and unusual definitively for non-capital cases, but has significantly narrowed the death penalty.
How so?
It's banned for those with intellectual disabilities, for juveniles under 18 at the time of the crime, generally for crimes not resulting in death, like rape, and mandatory death sentences are unconstitutional.
But the U.S. still carries out executions.
Yes, it's among the countries with the most, though the per capita rate isn't the highest globally. Public opinion seems to be shifting against it, though, maybe due to lower crime rates and DNA exonerations. More states are abolishing it or stopping executions.
Okay, that covers the first 8 amendments. The Ninth and Tenth's more about interpretation and power, right?
Exactly. The Ninth says listing specific rights doesn't mean other rights retained by the people are denied. It's a safety net.
For rights not explicitly written down, like marrying, working, raising kids.
Things like that, yeah. Common law rights, natural rights. Justices disagree on how broad it is. Some think new rights need formal amendments. Others see it as protecting fundamental, unlisted rights, especially for minorities. The right to privacy is often linked to the Ninth.
And the 10th Amendment, that's about federalism.
Pure federalism. Powers not given to the feds nor denied to the states are reserved to the states or the people. Chief Justice Stone called it a truism, just stating how the system works.
It's still debated. State sovereignty versus federal power.
Always. Ideas like nullification haven't held up in court, generally. Courts have pushed back when the feds try to force state officials to act or coerce states into federal programs by withholding existing funds.
But the 10th does let states offer more rights protections than the federal level.
Absolutely. Free public education, victims' rights, right to hunt fish, state ERAs, early women's suffrage in Wyoming, all examples. California even used its constitution to protect speech rights in some private shopping centers.
Based on the Pruneyard case.
That's the one. Of course, federal laws restricting rights override state protections, like with weapons or drugs, though state marijuana laws are a complex exception. It raises interesting questions about state constitutions. Should rights be added or removed at the state level? Worth looking into your own state's constitution.
Okay, let's wrap up with the right to privacy. Not explicitly in the Constitution, but hugely important.
Right. Scholars argue it's implied in several amendments, the 3rd, 4th, parts of the 5th, and 14th. The idea of a zone of autonomy free from government intrusion, especially in the home. Warren and Brandeis wrote about it way back in 1890.
And some state constitutions do explicitly mention privacy.
They do. The Supreme Court formally recognized a constitutional right to privacy starting mid-century with Griswold v. Connecticut contraception for married couples.
And privacy issues fall into 2 main buckets: sexual intimate conduct and surveillance.
Broadly, yes. Sexual privacy expanded from contraception to unmarried people, then most controversially, to abortion in Roe v. Wade, 1973.
Roe established a right to abortion based on privacy, using that trimester framework.
Yes, balancing the woman's choice against state interests. But it's been under constant attack. Planned Parenthood v. Casey, 1992, introduced the undue burden test, allowing more restrictions like waiting periods and parental consent, but striking down things like spousal notification.
And restrictions continue to mount at the state level. affecting access.
Definitely. Though Whole Woman's Health in 2016 did strike down some Texas rules, but the fight is ongoing, with the Supreme Court recently agreeing to hear a Mississippi case that could dramatically curtail abortion rights.
Privacy rights also expanded to cover consensual adult sexual relationships in Lawrence v. Texas, striking down sodomy laws.
Correct. Though sexual morality is still regulated in other ways, prostitution, polygamy, obscenity laws, etc.
Now the other side, privacy from surveillance. Technology has changed everything here.
Massively. License plate readers, easy pass tolls, GPS, facial recognition, smartphones constantly tracking us, stingrays mimicking cell towers, maybe even remote mic activation. It's pervasive.
Used by government and business.
And even anonymized data can often be traced back. Add drones flying overhead, infrared cameras. It really challenges the Fourth Amendment, written for a different world.
Laws like the Patriot Act expanded government monitoring powers too.
Yes, raising concerns they're used beyond just terrorism. Europe often has stricter data privacy laws. The Apple versus NSA encryption fight highlighted this tension too.
But Carpenter was a big step, requiring warrants for cell phone location data.
A very significant ruling applying Fourth Amendment principles to modern tech. Groups like the EFF keep pushing on these digital privacy fronts.
So there are potential benefits to this tech, catching criminals, traffic flow, but huge risks too.
Exactly. We need limits, vigilance. It makes you wonder, how much privacy should we give up for safety? And could those repressive regimes of the past have maintained control with today's tech? Serious questions.
So recapping this deep dive, we've looked at what civil liberties are, where they came from, the specific rights in the first 8 amendments, how they're interpreted, and this huge issue of privacy.
Understanding these rights and their limits and how they're balanced, it's just fundamental for anyone trying to be an informed citizen.
Absolutely. And that balance, it's not static, is it? It's constantly shifting with history, technology, and public debate.
Constantly evolving. Hopefully, thinking about all this gives you a clear lens for considering where that balance should be struck today.